Hello, today we will talk about jurisdiction of the civil court. Civil courts have jurisdiction to try civil suit of any nature unless expressly or impliedly barred. So, secondly, the question to determine whether the court has the jurisdiction or not is on the civil court itself. Civil court has inherent jurisdiction to decide whether it has jurisdiction on a particular matter or not. Thirdly, the consent can neither confer nor take away the jurisdiction. So, consent of the parties can neither confer nor take away the jurisdiction. Fourthly, courts can also not restrict or confer any jurisdiction. Jurisdiction is given by the statute, by the legislature. It is the sole act of legislature. They can give jurisdiction and they can restrict the jurisdiction. Even though the high courts and the Supreme Court, they have a supervisory power and the subordinate courts are there and they have supervisory power, etc. That is all true, but they don't have the power. If any statute has already given jurisdiction to a particular civil court, then they cannot take away that jurisdiction. Suppose if a statute has not given the jurisdiction to a particular civil court in particular matters, then high courts and Supreme Court cannot give the jurisdiction to a particular civil court to whom the jurisdiction is not given. So it is a sole act of legislature. They can confer by statutes and they can also proscribe and limit particular civil court. Now, we must have heard about the contracts, and generally contracts do refer that a particular civil suit, if civil dispute, if case arises, it has to be tried in a particular court. So the contract which totally prohibits the jurisdiction of any court, that is obviously illegal, because that no contract can be made in contravention of the law, and that will be against public policy, because ousting totally the jurisdiction of the court is altogether illegal, and that is totally unwanted and totally against the public policy. Because if a particular party wants to have a remedy later on, then they cannot have by the contract. But constitutionally everybody has the right to get the help of the civil court and any court for that matter, if the time arises and if they have a suitable case. So that's why when the power to go to the civil court or power to go any court is conferred by the constitution in a particular suitable case, then how can two people with the agreement restrict that power which is conferred by the supreme legislation, that is the constitution, upon every individual? So that's why that total prohibition of accessing any court is totally illegal. However, if a particular property or something is coming into territorial jurisdiction of two civil courts, and there is a contract that in case of a dispute the parties shall refer to particular court of this particular state, for example Bombay, then that is totally legal, because there the parties are not totally ousting, not totally taking away the jurisdiction of civil court. They are only taking one jurisdiction. Out of the two, they are taking one, so that is valid. Now, as we go further, Jurisdiction. Now what the question also arises is, what do we mean by jurisdiction? Now jurisdiction, stated simply, is the power or authority to decide the matter. The power or authority to decide the matter. Now what kind of jurisdictions can be there? First, there is a territorial jurisdiction. As we know, the state has divided the courts into various jurisdictions. A particular court, a district court, has a jurisdiction over the district. High court has a jurisdiction in a particular high court, like that. So that is the first jurisdiction, that there is a territorial jurisdiction. Second jurisdiction is pecuniary jurisdiction. Suppose court of small causes cannot entertain suit which is about 10,000, so that is a pecuniary jurisdiction. Then the third type of jurisdiction is jurisdiction related to subject matter. Suppose there are family courts, they are designed to adjudicate upon family disputes, divorce cases, etc. Then there is income tax tribunal. They are specifically designed for income tax matters. So now there is a income tax dispute, then the income tax, then it can be resolved in the income tax tribunal, etc. So for family matter you can go to the family court. So likewise there is a jurisdiction of the subject matter also. So these are the three main jurisdiction. Then we can also say that there is a foreign jurisdiction. Foreign jurisdiction is of a foreign court. Foreign court is any court which is continued or established, or if established, it is not continued by India. If it is established or if it is continued after establishment by with the help of the central government, then that will come within the purview of Indian court. So any court which is situated outside of India and which is not established nor continued by the central government of India, then that is a foreign court. So such courts have foreign jurisdiction. Now the other thing is that if a matter is pending in the foreign court and that will not bar the parties to institute a suit in India also. That is also one of the principles of res judicata, that the bar and the restriction will apply only in case of courts which are within the India, within the boundaries of India, or within the ambit of central government. So foreign courts have foreign jurisdiction. Then similarly we can say there is also local jurisdiction, as for example a civil court has a jurisdiction over the suppose a district court has a jurisdiction over a particular district. Suppose if we go to a particular Bandra court, it has a jurisdiction up to particular area. Likewise we can also that there is a local jurisdiction. So now the further thing that we will discuss now is that what is the difference between and what is the consequence of lack of jurisdiction altogether and irregular exercise of the jurisdiction. Suppose if there is a lack of jurisdiction altogether, then the decree passed by a court, in that matter will be totally null and void, and the opposite party can go at any stage of the proceeding and get the decree null and void. However, if the court has jurisdiction, and there has been some irregular exercise, there has been some mistake, irregular exercise of the jurisdiction, the court has not given a correct decision, so then that is not invalid. That is not null and void. The decree is not null and void. What will happen is, in such a case, the party which is aggrieved by such a decree can take the course of the regular proceedings of appeal or revision, whatever is there, because it is said that when the court has a jurisdiction, then the court has not only the jurisdiction to try the suit rightly but also wrongly. So if the court has jurisdiction, then the court has jurisdiction not only to try the suit rightly but also wrongly. So if there was a jurisdiction and the court have exercised it, and then there is some mistake, irregular exercise, then that is not invalid, that is not null and void as per the law. But if there is no jurisdiction and then the court assumes jurisdiction, then if the opposite party which is aggrieved by it, if that party decides to take the action against that decree, then that decree can be null and void, because the lack of jurisdiction altogether goes to the root of the matter and vitiates the whole trial. Lack of the jurisdiction altogether goes to the root of the matter and vitiates the whole decree, the whole trial. So that is the difference between lack of jurisdiction altogether and irregular exercise of jurisdiction. So now the third thing is again that who will decide whether the jurisdiction is there or not. Then the courts, civil courts, have inherent jurisdiction to decide whether the particular case is within its jurisdiction or not. And it is not just a thing, it is a compulsory duty also. It is the court is bound to decide whenever any matter goes to the court. It has to first decide whether the particular matter is within its jurisdiction or not. Then the principles related to this jurisdiction matter we can sum up as the question related to jurisdiction can be decided by the court itself. The civil court can decide whether the court has the jurisdiction or not. Secondly, generally it is to be assumed that the court has jurisdiction. The presumption has to be in the favor of the jurisdiction, that the court has the jurisdiction, unless expressly or impliedly barred by the law. So unless expressly or impliedly barred, and if there is such restriction, then that statute has to be strictly constructed. If there is such bar, then that thing has to be strictly constructed. Otherwise, because the presumption has to be in the favor of the jurisdiction and not against it. And another point is that even if there is no jurisdiction, court can still consider the point as related to whether the provision of the acts have been followed or not. That much they can consider even though there is no jurisdiction. So that is another thing. And now how the court's jurisdiction will be ousted. Suppose if the statute has created any special machinery. For example, income tax related matters, it has created income tax tribunal. For matters related to workmen compensation, etc., there are industrial tribunals. So when the statute creates a specific remedy and a specific procedure, and it has conferred all the power to decide that matter, then that court shall decide the matter. Now, in such a case, suppose if there is a specific tribunal, specific courts have specific remedy is given by the statute. Now, in that kind of situation, civil court can exercise jurisdiction only when that particular enactment has not conferred the full power on that particular court to decide the matter. If it has not given that particular court, if that particular tribunal full power to decide the matter, then civil court can still assume and it can still proceed with the jurisdiction. But if it has conferred all the powers required to decide upon that matter, then the civil court cannot assume the jurisdiction. Then that jurisdiction will be with that particular tribunal only, particular court only. So now let us recall the principles. The principles we discussed is that these principles are very important to remember. Apart from whatever we discussed, is that civil courts have jurisdiction to try all matters of civil nature unless expressly or impliedly barred. Secondly, the presumption will always be in the favor of the jurisdiction. Presumption will always be in the favor of the jurisdiction. And if there is a bar, whether express or implied, then that statute has to be strictly constructed. As far as possible, the presumption will be in the favor of jurisdiction. Fourthly, the consent can neither confer nor take away the jurisdiction. Consent can neither confer nor take away the jurisdiction. Fifthly, the fifth principle is that there is a difference between lack of jurisdiction altogether and irregular exercise of the jurisdiction. If there is lack of jurisdiction altogether, then it will go to the root of the matter and it will vitiate the whole trial, and the decree passed in such a case will be null and void, and the aggrieved party can opt to take the further proceedings and get the decree null and void. But if there is only irregular exercise, if there is a jurisdiction but there is some irregular exercise, then the aggrieved party can take the normal course of action whichever is there. Suppose it can go to appeal, revision, review, because it is assumed that if the court has the jurisdiction to decide the matter rightly, then it has also the jurisdiction to decide the matter wrongly. And suppose if the matter is wrongly decided, then the aggrieved party can go to the court, the proper court which is provided in that particular situation, whether appeal is provided or revision is provided or whatever it is. But if there is irregular exercise of the jurisdiction, if there is some irregular exercise of jurisdiction, the jurisdiction was there, but there was some, a wrong decision given, a wrong order passed, a wrong decree made, anything like that, then the aggrieved party can take the normal course of action as per the provisions of that particular law, particular situation, appeal, revision, whatever it is there. So today we have discussed about the jurisdiction of the civil court. I can talk many more points also, but I think this shall be enough for us. and I have spoken from whatever